Hello everyone, welcome to Administrative Law. In this unit, we'll be looking at the executive branch of the Australian government and the kinds of decisions that they can make and the ways in which citizens can examine, maybe even challenge those decisions and hold the government to account for those decisions. This week, we'll be focusing on the theories, the history and the context in which administrative law occurs. We'll start off by looking at the broad question of why administrative law matters. Why is this a significant subject to be studying? We'll then focus on the role of administrative law within the Australian legal system, and we'll take a look at some of the key administrative law principles. Some of these might be familiar to you from other units, such as the separation of powers, which you would have talked about in constitutional law, while others might be a bit new to you. From there, we'll take a step back and we'll give an overview of the course as a whole. And I'll present a bit of a roadmap of where we're going with this unit. And lastly, we'll talk through some of the critical unit information, such as assessment, reading resources, and things like that. But to jump straight in, why does administrative law matter? In its simplest form, we can think about administrative law as providing accountability and an external check on executive decision-making. So you'll remember from hopefully constitutional law, but maybe some other units as well, that we can divide government power and sovereignty into three branches: the legislature, the executive, and the judiciary. The legislature makes laws, the judiciary interprets laws, and it's up to the executive to enforce laws or to carry out or administer laws. And so in this unit, we're really focused on that middle branch, the executive, how they go about their job and what the ways in which that impacts us as citizens and the things that we can do about to ensure that the executive is doing its job properly. Now, administrative law and executive decision-making affect our lives in a huge array of ways, but sometimes it's most helpful to think in extreme examples. So I've got here on these slides three of the most dangerous documents in the history of the world. And I'll talk you through them because they really highlight the sheer scope of the power in which a modern executive government can operate. So the first document I'd like to show you is an order from the office of the US president towards the end of the Second World War, authorizing the use of atomic bombs on particular cities in Japan. And what's really significant about this document, other than the sheer power and horror of dropping a nuclear bomb, is the way that it's written in very sort of clinical terms, as you'd expect, but it authorizes the initial drop and suggests a few targets that might be selected, including Hiroshima and Nagasaki. But what's interesting at bullet point 2 is that it authorizes additional bombs to be dropped as soon as they're ready. And so once that initial authority has been provided by the US president, people much lower down the military hierarchy had complete authority to drop these horrific weapons without any need for further approval or permission. And what's really important about this document is that it really highlights the power of the executive to unleash, just horrific weaponry on the citizenry of another country. The second document I'd like to show you also comes from a similar time period, and it's the document which in English is referred to as the final solution. An executive order allowing the Nazi government to round up and begin killing off Jewish people and other minorities in Nazi Germany. Again, this is a decision by the executive government and legal under the laws of Nazi Germany at the time, although as we know, historically, it was, terrible. But what's significant, again, is that this is an executive government acting without much oversight and completely within the laws of the time. The third document I'd like to show you is a certificate of exemption that took place. It was issued during the period in time in Australia, which we come to know as the stolen generation, where Indigenous Australians were forcibly removed from their families. And this was all done through a legal process. It was legislated for at the time under the Aborigines Protection Act. And what's striking about this example is that it's a certificate of exemption. So not only was the forced removal of Indigenous children from their families legal at the time, but you actually needed permission from the government to avoid being removed from the family. So this really highlights the power of the executive government in Australia. And this particular example is from New South Wales, but this was a policy that was in place right across Australia throughout much of the early 20th century. And what it highlights again is this was a completely legal decision. It was completely removed from the parliamentary process. It was a decision by the executive government. There was no chance for citizens to really participate in the making of that particular decision, whether an exemption should be granted in that instance. Little parliamentary oversight, no debate, no rigor in a democratic sense. This was purely occurred under the executive limb of the government. And so these are three really extreme examples, but I think what they highlight is the sheer scope of power that executive governments can wield and the way in which administrative decisions can have a tremendous impact on the lives of citizens. To bring it, I suppose, a bit more closer to home, some more, I guess, mundane administrative decisions that might affect your lives include the issuing of a driver's license. That's an executive decision. Department of Transport or Main Roads decides whether you can drive around legally or not. They're responsible for setting whichever requirements or age limits or tests, and they're responsible for setting limits or restrictions in terms of P plates, restricting certain classes of vehicles to certain drivers and things like that. That all happens under the executive branch of government. Centrelink and other sort of social welfare payments are executive decisions. The decision whether you are eligible or not, even though it's quite formulaic and follows a set criteria and there's usually very little discretion, it's still a decision within the executive government whether you are eligible for a particular payment or not. And there's scope to sort of vary the amounts as well within the executive. More recently, with the coronavirus, we've seen a lot of travel restrictions, restrictions on numbers of gatherings and things like that. While some of this has been legislated and gone through the parliamentary process, a lot of these are executive decisions because some states are operating under a state of emergency, but also the day-to-day restrictions on travel and the decision to allow some people to travel and not others is an executive decision. When you apply for, say, a border pass to get into Queensland, it's an executive decision, an administrative decision, deciding whether you can whether you'll be granted that pass or not. Payments to government are also broadly fall within administrative law. So, for example, the amount of tax that you owe, whether you have to pay stamp duty when you sell your house or things like that, or when you buy a house, I should say. These, while they have, specifically under revenue law, they're their own thing, but broadly they fall under the administrative umbrella. These are decisions that an executive makes about your tax liability or things like that. And then perhaps if you wanted to own an exotic animal or to breed pets or something like that, you might have to have a permit or a license. And that's another example of an administrative decision. You'd have to show that you've got whatever the requirements are. Maybe you have to have a certain amount of land or certain qualifications. You have to show that you've got a good enclosure, whatever it is. It's an administrative decision whether you should get that permit or not, whether you should be allowed to own that particular animal or breed that particular animal. So these are, I guess, some more basic ideas or examples of administrative decisions that affect your day-to-day life. Taking a bit of a step back and thinking about administrative law as a unit of study within your law degree, you might have heard a thing or two about administrative law or have some preconceived ideas about what administrative law is. And in particular, it's got a bit of a reputation as being hard and or boring. And I'm a bit biased. I think that that's probably an unfair way to characterize administrative law, but I think it is worth addressing because it is a common belief about administrative law. And so it's worth thinking about, well, what is administrative law really like, and to sort of manage some of those expectations before we head into the unit as a whole. I think that people find administrative law hard or boring because they often don't see that relevance to their own lives. And I've tried to show in these last couple of examples that administrative law can be really impactful on your own life, but sometimes it is a little bit hard to see the day-to-day relevance. Most people don't practice administrative law in their legals career, so it can be a little bit hard to bring that sort of relevance to your studies. What I'm going to try and do throughout this unit is highlight ways in which the course is relevant to you personally, but also to think more broadly at a societal level. These are decisions, thinking, for example, about Centrelink payments. Over the past few years, there's been a large controversy over robo-debt. Some of you may have even, have been affected by that yourselves. The ways in which decisions of government are made and impact people all around Australia are really important for society as a whole. And so I can see why some people find administrative law boring. I obviously personally don't feel that way. But I think if you're constantly throughout this unit thinking about the ways in which decisions of government either affect you, affect people in your family, or affect society as a whole, it does help to bring forward some of that relevance. And the political context can be quite fascinating around some of these decisions and the cases that we'll look at. In terms of administrative law being hard, I think it's certainly a complex subject, and I think that that's something that is really important to stress to you going into this unit, is that there is a low level of complexity to administrative law that you need to be upfront about that, and you need to be aware of that. But one thing that is really important to understanding administrative law is understanding the decision-making process, and therefore the follow-up process of how we go about understanding that decision and perhaps challenging that decision if we need to. And so one thing that I'm really going to emphasize in this course is where we are at each step along the way, why we're at that point having regard to previous steps, and also where does that take us moving forward. And so I'm going to put up a few resources on the Moodle. Hopefully you will have seen them as you explore the course, that really step out the overall structure of the administrative law process. And that process itself is pretty straightforward and quite easy to follow. The complexity is in the detail within each of those. But if you understand in a broad sense where we're at and where we're going, that really does help contextualize the detail, and it allows you to focus on that rather than trying to madly catch up and figure out, well, where am I? Where are we going with this? So if you are feeling a bit lost, it is really important and really helpful to take a step back and think about the broader context of an administrative decision and where we are going in the legal process in challenging that administrative decision. But above all, the point I would make is that really administrative law is the kind of unit that you get out what you put in. If you go in thinking admin law is going to be hard and boring, it's probably going to be hard and boring. If you go in with an open mind, if you go in interested in the broader contextual factors, interested in the political factors that make individual cases really interesting, if you go in ready to see how administrative decisions affect your day-to-day lives, then it won't be boring. If you go in to admin law embracing the complexity, then it won't be hard. It's actually quite straightforward once you embrace the details at each step along the way. So don't be scared of admin law, be excited. Is probably the message that I'd try and instill in you in these early stages. So what is the role of administrative law? I've alluded to this a couple of times, but it's worth sort of stating outright. And this is a diagram from your Week 1 study guide. Admin law is the bridge between executive government, the decision-making, the administrative limb of sovereign power, and citizens, the governed. The people who are affected by decisions of government and the administration of law. Admin law is the bridge between those two groups. And in particular, in admin law, what we're looking at is the ways in which administrative decisions are made and enforced, and the ways in which citizens can review or challenge those decisions. How do we hold the executive government to account? And make sure that they are governing properly on our behalf. Really, that's the core and the role of administrative law. So in terms of scope, what we're thinking about is the way in which we can review decisions of the executive, ways in which we can understand how a particular decision was made. If a poor decision was made, how do we correct that? And through that process, how do we protect people's rights? How do we ensure that the government is ensuring that people's rights are not interfered with unnecessarily? How do we ensure that people are being supported by government rather than downtrodden? And lastly, the sort of scope of administrative law is to provide public accountability for government processes. Making sure that government is open and transparent and that's important. We'll talk about that more in Week 2, but that's really important because government that is open and transparent in its decision-making is generally thought to do a better job. If we hide decision-making processes away in secrecy, there's room for, at the worst extreme, corruption, but even just poor process, poor planning, poor decision-making. And so making decisions open and transparent improves the quality of those decisions and improves the quality of governance as a whole. So some key principles that are going to guide us through this course include the separation of powers, which you'll be familiar with, hopefully. The separation of government power into the legislature, the executive, and the judiciary. And in particular, in administrative law, what we're interested in is the judiciary providing a check on executive power, reviewing the decisions of the executive government and making sure that those decisions have been performed properly and in accordance with the law. At the same time, thinking about the separation of powers, we've got a fair amount of judicial deference to the legislature. It's not up to the judiciary to decide whether a particular law is good or bad. It's up to the judiciary to decide whether the executive followed that law or not. And so this is really important from a democratic perspective because the legislature or parliament are the ones who are elected by the people. And so it's not the role of unelected judges to challenge the laws that are passed by the people's representatives. It's their job to make sure that the executive has done the right thing in carrying out those laws. So this is how we see sort of no one level being held too high above the others. The judiciary provides a check on the executive, but is deferential to the legislature. Another key principle is administrative justice. So making sure that the decisions of the executive government are just and fair and right and proper. Making sure that due process has been followed, making sure that the decision that is reached is fair and equitable under the circumstances. Another key principle is executive accountability. We've talked a little bit about that already. The role of administrative law in holding decision makers to account. Where they make an incorrect decision or a poor decision, making sure that that is acknowledged and fixed rather than being allowed to just let slide. And that's important on an individual level for justice, to make sure that the decision that affects them is the right decision. But it's also important from a societal level because it improves the government decision-making moving forward. Correcting an error in one instance hopefully prevents that error from happening again. And lastly, and this sort of ties the other principles together, we've got a key principle of good administration. So making sure that the administrative decisions that are made are good quality, of a high standard, making sure that the executive government is operating as efficiently as possible, as effectively as possible, and making the right decisions as often as possible. Some key challenges in administrative law that we'll keep in the back of our minds throughout this unit. For one is the public-private divide. Obviously, in focusing on government and the executive government, we're falling under the umbrella of public law. Administrative law at its core is about the relationship between citizens and their government. But what we're seeing in Australia and right around the world increasingly is privatisation of government functions, contracting out of enforcement, of decision-making, of policy development. And so quite often these days we have examples of private companies or private individuals making decisions that have the effect of an administrative decision for the government. And so this is a really interesting challenge because it throws into question a lot of the ideas that we have about government decision-making and the powers of the sovereign to make decisions that affect individual citizens. A really good example of this recently comes from Victoria and the sort of the hotel quarantine scandal that's been rolling around. As a very brief summary, and facts are still rolling out at the time of recording, but what it appears to be from the inquiry is that the Victorian government instituted a hotel quarantine system, like a lot of states, in order to try and combat the spread of coronavirus. But rather than using the police as a public institution to enforce that quarantine, they hired out private security companies to enforce that. And there were a lot of problems with that in terms of lax security and a whole range of things. It's a really interesting administrative problem because it raises this question about how much responsibility does the government have for those mistakes. As a whole, they take ownership for the regulation of the coronavirus quarantine, but the mistakes were made by individual private companies. And so there's this really interesting dichotomy that's going on at the moment about where blame exactly lies. And for people who were affected in Victoria who either got coronavirus or lost loved ones to coronavirus, where's the justice for them in this situation? Who do they hold to account for those poor decisions? Another really key challenge moving forward is in the realm of artificial intelligence and autonomous decision making. So increasingly, government decisions are made by computers, artificial intelligence, machine learning, which is really good from an efficiency perspective because it allows decisions to be made more quickly. A computer can process a lot of information a lot faster than a human can. So from an efficiency perspective, this is really good because it means that decisions are made faster. For example, you apply to a government for particular funding, you want to renew your license, the turnaround time is really quick compared to when it's a human making the decision. It can take a lot longer. The problem, as we've seen, is that, for example, with Robodebt, Centrelink issued heaps of debt notices to people who didn't actually owe any money because of an error within the autonomous decision-making system. In a scenario like that, we've got a really difficult question and a difficult challenge in relation to, well, who was the decision maker and who's responsible for that decision? We can't hold a computer to account in the way that we can a human. And so this is going to be, moving forward into the future, this is going to be a really critical area of administrative law. How do we integrate the good elements of artificial intelligence into government decision making while still maintaining those key principles that we talked about earlier about good administration, administrative justice, and things like that? So those are two issues that we'll keep in the back of our mind as we go throughout this unit and look into the various steps along the administrative process. As an overview of the unit as a whole, I think that it's probably more useful to you to see this as a mind map rather than a sequential list of the weeks, although I will provide that too. In a separate video, I'm going to talk through this sort of flow chart in more detail and explain more clearly how each of the weeks kind of fits together. But very broadly, we're in week 1, obviously, we're talking about theories of administrative law, or we've talked about that. Next week, we're going to talk about access to information, which is the way in which we access government data and the way in which we access a government's reasons for a particular decision. And from there, we branch out into 2 separate topics: merits review and judicial review. Merits review is a review of a decision on its merits, and it stays within the executive branch of government. So it's not a judicial process. It stays within the executive, and it looks at, well, could we remake this decision better? Was there a mistake made? Is there a problem? If we look at this all over again, would we arrive at the same decision, or could we reach a better outcome? And so we go down that path in week 3 and look at merits review and how that all works. Then for the rest of the course, we look at judicial review, which takes the review of a decision out of the executive branch and into the judicial branch. And that's really important as a distinction, because on the one hand, the judiciary has a lot more power to review a decision, but on the other hand, they also have a limit because of the separation of powers. There's a limit on what they can actually do with that decision. So we spend the bulk of the unit looking at the availability of judicial review. What are the circumstances in which you can ask a court to have a look at an administrative decision? We'll talk through the foundations of judicial review as a process, and then we spend a good few weeks looking at grounds of review. So specific, you can almost think of these as a cause of action, the specific problems with a decision that we can use to attack that decision and get the court to review it. And so we look at things like not having any evidence on which to base the decision, the decision maker being unauthorized to make that decision, the purpose of the law under which the decision was made, whether the decision maker looked at relevant or irrelevant considerations, principles of natural justice, and whether the decision was just completely unreasonable. So those are the bases on which we might review a decision. And then if we can make one or more of those grounds of review out, we can ask the court for a remedy, usually quashing the decision and asking the decision maker to remake it. I'll talk through that mind map in more detail in a separate video to really explain how it all links together. But this is to give you a general sense of where we're at in the course. And each week you'll see this slide, and I'll highlight where we're at and how that relates to previous weeks and future weeks. To present that information in a table form, these are the weekly topics. You'll notice that in week 5, there's no topic. That's because your assignment will be released at the end of week 4 and will be due at the start of week 6. We've got a vacation in the middle there as well. So I've given you week 5, no assigned topic, to give you a bit more time to spend working on that written assessment. We will still have a tutorial that week to talk about the assessment and for me to answer any questions that you've got, but it won't be, there's no new information to learn in week 5, and that should give you plenty of time to focus on the written assessment. These are my contact details, j.deem@cqu.edu.au. Please do feel free to get in touch if you've got any questions or concerns throughout the course. I do aim to reply as quickly as I can. There's also plenty of avenues to contact me in the discussion forums on Moodle and for you to get in touch with your peers as well. But I do acknowledge, I gave the disclaimer that, administrative law is not as hard as its reputation allows sometimes, but I do acknowledge that it is a really complex course. And so if you are feeling lost or feeling like you're struggling, absolutely, please do get in touch and we can sort it out. It's much better to, spend a little bit of time talking through it than to feel like you're completely lost and you don't know where we're at with this course. Some key resources for this course. The textbook I've prescribed is Control of Government Action. What I really like about this textbook is that it does go into a bit more of the background and the context of administrative decisions. And so in terms of thinking about administrative law's relevance, in terms of thinking about, the broader context, it's a really great book. If you are more interested in just the black and white letter of the law, there are a couple of other resources that I can point you to. So if you are looking for something that's a bit more tightly focused, please do get in touch. I can point you in to a few other textbooks that you might find more useful instead. But I really regard Control of Government Action as more of a complete package. And that's why I've assigned it as the prescribed textbook for this week, for this unit. You've also got the study guides on Moodle, the key concept videos like this one, and then our weekly tutorials. So you've got, I suppose, a complete package. And if you want my advice, or certainly the way that I've tried to set up these different resources, probably the order in which I would recommend that you view this stuff is have a look at the weekly video or videos of each week, because they're really set up as an introduction rather than a comprehensive overview of the topic. It's just pulling out a few key points, describing the relationships between this week and previous weeks, and really giving you sort of a taster of what you're going to see in the study guide and in the textbook. So I'd watch the video first. I would then read the study guide and read the textbook to give the sort of the broader understanding of the particular topic. Then there'll be some tutorial questions and discussion questions for you to go through. And then, of course, we have our actual tutorial, our 1 hour session each week, where you bring all of that knowledge to bear. We'll go through some practice questions. We'll talk about how to construct an answer from the perspective of your written assessment and the end of semester take-home assessment. And so the tutorials really should be the pinnacle of everything that has come before. Speaking of assessment, there's 3 broad assessment tasks. There's weekly online quizzes, each worth 1%, so for 10 throughout the term. What's really critical is these start from week 1. So Monday of week 1, there is a 1% quiz up for grabs. You get 1 week to do each one, and after it's closed, it's closed. There's nothing that I can do about it. There's nothing anyone can do about it. You've got a week to do that. Because it's only individually, it's only worth 1%. It's not worth your trouble to go through the extension process, an alternate quiz, all that sort of stuff. So individually, each one, is only worth 1%, but together they're worth 10%. And that could be the difference between, a HD and a D, or a distinction and a credit, things like that. So it is definitely worth your while going through and giving it your best shot with that. So let me just stress again, the first one is released on Monday of week 1. So we do really hit the ground running with this course. You've got a written assessment released at the end of week 4, and it's due on the Monday of week 5, but we do have a vacation week in the middle. And as I said, week 5, you've got no topics. So there's plenty of time to do that assessment. And what you have to do is you'll be given a hypothetical scenario, and you'll answer a couple of questions based on that. Then at the end of the term, we've got a take-home assessment, which again, questions are based on a couple of hypothetical scenarios, and that will be scheduled in exam blocks. So I'll be able to give you the details of that closer to the time. That takes us to the end of the week 1 videos. Thank you very much for watching. As I said, please do get in touch if you've got any questions, and I look forward to seeing you all next week. Thanks very much. Bye.